G'day everyone, and welcome to the 18th Agony Anth, part of my collaboration with the Charles Darwin University Law Student Society. This week, I've been asked how lawyers deal with self-represented litigants. Just a few decades ago, self-represented litigants were virtually unheard of in our court system. Back in those days, we had a much less litigious society, and so people were much less likely to be involved in court proceedings, and we had a much better funded legal aid system. These days, especially in family law proceedings and increasingly in civil proceedings, lawyers are more and more likely to find that their opponent is representing themselves. Now, this is also true in some other types of proceedings, such as tribunal proceedings, where legal representation is not even allowed, and criminal proceedings where the punter merely seeks to plead not guilty. I'm not going to be talking about those types of proceedings in this video because, as a lawyer, you're unlikely to be involved in tribunal proceedings unless both sides are represented. And in criminal proceedings, you're unlikely to be against a self-rep unless you're a prosecutor, which is a pretty specialised field. Most lawyers encounter self-reps in family law or in civil proceedings. So why does someone become a self-rep? There's a number of reasons, and they lead to very different types of self-rep. The first and probably most common type are the self-reps who cannot afford legal representation. Legal aid is now restricted to only support those in the most dire poverty. Most people are caught in a situation where they don't qualify for legal aid, and yet they can't afford the fees charged by most legal firms. As a partner in a firm, let me tell you, it's essentially impossible to run a firm in a way which pays the staff a decent salary, without charging fees that quickly outstrip the capacity of most people to pay. Litigation is expensive. Sometimes these capacity to pay self-reps might have started out with a legal firm and then the money might have run out. Other times they might have obtained assistance, for instance from a community legal centre, but not actual representation. Many times though, these self-reps are simply confused by the system, frightened by the consequences of getting things wrong, and overwhelmed by the entire scenario they find themselves in. Second, there are self-reps who I think of as the passionate true believers. These self-reps believe passionately in the justice of their cause. They've often previously been to see a solicitor and they might not have gotten the answers they were hoping for, so they continue to fight on their own. In their mind, they're Erin Brockovich. These self-reps are often aggressive. They believe you as a solicitor are part of a conspiracy to defeat the justice of their cause, and they're often impossible to negotiate with, even on simple points. They're often so passionate that they spend hours upon hours researching their case, and they still usually come up with the wrong answers. They'll send you a 300-page affidavit and 56 cases, which they allege are their authorities. Finally, and just occasionally, you'll come across self-reps who are intelligent and articulate and who've made a measured decision to represent their own interests. For instance, a man named Jorai Pangilinan, in prison for murder, had his parole application rejected. With no training in the law and no online resources, writing his submissions in biro in his prison cell, he took on the parole board in the Supreme Court and the Court of Appeal, and he won both times. You can read the judgments on Osley. Most self-reps are obviously operating with huge disadvantages. First and foremost, they rarely understand the law. Even if they can manage to find the right bit of statute, they often have no understanding of how to read it or how to look for the cases where that section has been interpreted. Often they will seize on a few words in a particular section which seem to support their point of view, and they'll hang everything on their personal interpretation of those words. So not only do they not understand the law, but they often fail to even recognise that they don't understand the law. Beyond that, one of the things that you've certainly learned as a student is that the law is not inherently just. The law often produces outcomes that seem entirely unjust, at least to the losing party. Self-reps often feel that they have justice on their side, so the law must mean what they want it to, because the law wouldn't be unjust, right? Second, self-reps often don't understand the procedures and particularly the pre-trial procedures that they're required to follow. They will blithely ignore directions to file and serve materials. They'll file affidavits full of irrelevant or inadmissible material. They'll try to drive up your client's costs by sending you a deluge of nonsense. They will hold back things that they ought properly to disclose and then try to surprise you with them on the day of trial. Often, again, this is just pure ignorance. They have no idea of what's relevant or what's permissible or what the procedural directions actually mean. And when they watch legal shows on TV, nobody ever shows the pre-trial paperwork process. Third, and most importantly, self-reps are too close to the outcome. Part of what we offer as lawyers is that we are emotionally disconnected from the dispute. When it's your kids or your business or your financial well-being in dispute, it's easy to lose that sense of professional detachment. Self-reps will say things like, I'm just going to go to court and trust justice, or I'm going to stand up to you no matter what, or I want my day in court. Now, obviously, our clients often say those things too, but as lawyers, we can respond with compassion and empathy while still guiding them away from futile and costly actions. Nobody's doing that for a self-rep. In fact, their family and Facebook friends are probably egging them on with a dozen "you can do it" memes. So how do you deal with a self-rep? The first thing to remember is that the supreme duty of every legal practitioner is our duty to the court. Our duty to the court is even higher than our duty to the client. And as officers of the court, we are obliged to help the court to do justice. Under the Uniform Civil Procedure Rules, we are required to facilitate the just and expeditious resolution of the real issues in civil proceedings at a minimum of expense. As a result, there's nothing to be gained by taking an overly technical approach with a self-rep. Obviously, with our greater knowledge of procedure, we can run rings around them. We could spend hours pulling apart their pleadings, their affidavits, and everything else, attacking them for every breach of the rules. But that wouldn't facilitate the just and expeditious resolution of the real issues at a minimum of expense. And so, in reality, when dealing with self-reps, most lawyers do two things. First, they turn a blind eye to the self-rep's failures to follow procedure, unless those failures are going to have a genuine material impact on their client. A judge isn't going to have much patience with you if you take technical points with a self-rep just for the sake of taking technical points. Second, as much as they reasonably can, lawyers help out a self-rep. You need to be careful when doing this because you're not to provide legal advice to the self-rep. But there's no problem, for instance, with writing to them after a directions hearing to explain in plain English what steps they have to take to comply with the court's orders. Common sense has a lot of impact here. After all, there's no point and no value for your client in rocking up to court knowing that a matter is going to be adjourned off because the self-rep hasn't complied yet with the previous round of orders. You might as well try to help them move along. The second duty, of course, is your duty to the client. Now, it's good to have a conversation with your client early so that they understand that when you are trying to assist the self-rep, you're not somehow being a double agent working for both sides. You're still completely at liberty and completely bound by the duty to advance your client's argument as strongly as you're able. But if your client wants this to happen as quickly as possible and as cheaply as possible, they have to understand that their lawyer will be working hard to balance duty to the court and duty to the client. Communicating with self-reps can be a real challenge. Self-reps often don't understand that as lawyers, we are not personally involved in a matter. We don't put our egos on the line in every dispute. Because the self-rep is so emotionally caught up in their matter, it can be hard for them to understand that we are not. Again, self-reps are often using TV as a reference point, and legal TV shows emphasize aggressive disputes between the lawyers. In the profession, we get taught that our opponent is not our enemy. Self-reps can often find it very hard to make that distinction, and as a result, you can find yourself being treated very badly by self-reps who seem to think that insults and threats have some role to play in legal proceedings. The whole dynamic can make it difficult to give a self-rep the sort of assistance I was referring to a few moments ago. You might be genuinely trying to assist them, but if they've decided that you're some sort of fraudulent, unethical crook who's out to get them on behalf of your client, then no matter what you say, and no matter how helpful you're trying to be, they're likely to reject that and potentially do the exact opposite of what you're suggesting, just to prove to themselves that they can stand up to you. Responding to them, there's a fine line to walk. On the one hand, you're not obliged to let a self-rep treat you badly without responding. You're perfectly entitled to demand that they stop any inappropriate communication, and you're entitled to continue to put your client's position firmly and assertively. What you're not entitled to do is essentially bully the self-rep by taking unfair advantage of your knowledge and their ignorance. You could never, for instance, outright lie by telling them that the court would refuse to let them call a particular witness, say. My general rule of thumb is that I start by being very courteous to self-reps and genuinely looking for ways to resolve the dispute. I do my best to assist the self-rep to understand the legal nature of the dispute. If they get nasty or aggressive, then I certainly stand my ground. But I try to do it in a way that stops short of being rude or nasty. Try to remember, it's not their fault. As I said at the start, they're often confused, frightened, and overwhelmed. This has been a longer than usual Agony Anth, but it's an important topic. These days, it's almost inevitable that sooner or later you will find yourself on the opposite side of a dispute to a self-represented litigant. It's important to do your best to meet your duties to the court while still effectively representing your client. I can't believe we've already done 18 Agony Anths. Keep those questions coming, and I'll see you again soon.